It's Suzanne's legal tip of the day, and today we're talking about deposits. Can you refuse to give that back as if you're in a refund situation? Can you retain the deposit? Well, the first thing to consider is whether the person that is your customer is buying as a consumer. And if they are, then you have to consider that you need to have advised them of their 14-day cooling off period if they've bought at a distance, i.e. over the phone, through your website, through an email, etc. If you don't give them notice of that, then they've got 12 months from the date of purchase to cancel, so make sure you give them the notice. If they do cancel within that 14-day period, then you have to give them a full refund, regardless as to whether you've called it a deposit or not. You have to give them a full refund. You can't charge them an admin fee or bank fees or anything like that. It has to be a full refund. So if they're outside of the 14-day cooling off period or it's a non-consumer purchase, then we have to look at whether the term is reasonable or not. Now, if you're dealing with consumers, you need to be a lot more reasonable than if you're dealing with non-consumers. If you're dealing with non-consumers on standard terms, then you need to be reasonable to an extent. If you've got a negotiated contract with a non-consumer, i.e. a B2B contract, then typically there is not an implied duty of reasonableness to the same extent. So let's assume that they're a consumer. And let's see what the government says.